Muskan, please start.
Sure, sir. Any law which violates the inalienable rights of people is essentially unjust and tyrannical. It is not law at all. A warm good afternoon to everyone. I am Muskan Pandey, the moderator of the session is presenting on behalf of Department of Law, Prestige Institute of Management and Research, Indore. Would like to welcome our esteemed guest, Dr. Usha Tandon ma'am, respected faculties, and all dear students. Today, as panelists, we have Assistant Professor Mr. Kamlesh Jain sir, Assistant Professor Ms. Sayali Bandi ma'am, Assistant Professor Mr. Nakul Singh Chauhan sir, and Assistant Professor Ms. Navriti Dongre ma'am. Student coordinators Ms. Priyanshi Jain, Mr. Nishant Jain, and Mr. Kshitij Rajpurohit. And the members of the EML committee, Ms. Kashish, Ms. Garima, Mr. Yash, Mr. Vineet, Mr. Manjeet, and Ms. Kiran. It's my great honor to welcome our guest, Dr. Usha Tandon ma'am. Ma'am has pursued PhD in law and ma'am has graduated in LLB and post-graduated in LLM from Delhi University. Professor Dr. Usha Tandon ma'am is an eminent professor of environmental law, population law, gender justice, and family law with a teaching experience of more than 30 years. She is a world-renowned scholar for her work on human development, focusing on environmental protection and women empowerment. She has authored, edited several books on various aspects of law relating to environmental protection and women's rights. She has more than 50 research papers to her credit published in the journals of international and national repute. She has the honor of being invited by the Center for Human Rights and Humanitarian Law, American University Washington College of Law, USA, to pursue research on human rights and women's reproductive health 2004. Ma'am has received the recipient of World Population Day Award 2000 and Phenomenal She 2009. She served the director of a 5-year law school, Vivekanand Law School, GGSIPU, Delhi, 2005. As an expert, she participated in the National Consultation on Strategic 5-Year Plan organized by National Commission for Women, Delhi, 2010. One of her research studies on women and population has been published by the National Commission for Women 2010. Ma'am has presented her research work at various international academic platforms in different countries. Mere words are not enough to express the glory of Dr. Usha Tandon ma'am. In today's session, ma'am is going to enlighten us about women, property, and Hindu law recent developments. If any of you want to ask question during the session, you can write it in the Q&A box. Now, I request ma'am to kindly take over the session. Thank you.
Thank you, Muskan. Well, when I was invited to speak on any one of the topics of the family law, I had given the topic which is before you. I was under the impression that the students must have studied the family law, and this is an area which I believe the students must be very clear about the niceties of the law, and therefore that was a main reason why I have chosen this topic. But then later on, I clarified from the organizers that who are the students in this sense, whether there are scholars and what kind of. So I was told that they are our LLB students, and when I specifically inquired from them whether they have studied that family law, so I was told that so far they have not studied the family law. So when I came to know this thing, that I have to discuss this topic to law students, budding lawyers who have not so far studied this branch of law, it was a great challenge before me, how to take up this topic. Because this is one of the heavy areas of family law, very interesting, but yes, not that easy also. It needs certain things, certain basic understanding to know whatever concepts are herein. So, of course, I had to deal with these things, that the same topic, let the topic remain same, but somewhere or the other, I had to change my methodology in taking with this particular topic. So, Being conscious of the fact that you have not studied so far this subject, I'm going to explain this in a very, very simplified manner, not bringing the hardcore elements of law. Definitely, I'll be talking about the concepts of law which are relevant here, but not going into those hardcore technicalities. Right. Now, you will see there are so many words there in the title itself. If I start from the last one, it talks about recent developments. Recent developments of what? Of Hindu law, right? Now, recent developments, you cannot understand unless and until I tell you the basic law. Recent developments in the form of maybe new law, recent developments maybe in the form of the amendment. But amendment to what? Unless and until we come to know that basic law, we cannot understand the necessity of the recent developments. We cannot understand the importance of the recent developments. And therefore, it's going to be a very beautiful journey, which I'll be having with you in the next few minutes. And that journey will cover a law which spread over 1,000 years. Okay. Now, another term in the title is property. The context in which the property word is used herein is the property in the family. Okay, so when various family members have certain rights to the property, it may be more in the terms of succession rights or otherwise. So the property is contextualized in the context of Hindu law. Now come to the first word, woman. Now, in ordinary parlance, woman includes daughter, sister, mother, grandmother, aunt, niece, so on and so forth, right? But given the constraints of time, I'm giving 40 minutes to speak and then question answer session, as well as the stage at which my audience are hearing. I will confine myself to only one kind of the woman, so that whatever we are discussing, at least we have clarity about that. And one kind of a woman which is more important in all the women in the context which I'm talking about, that is the property rights under Hindu law. And therefore, I have chosen that woman, which is daughter. Okay, so can we have the next slide, please? Yeah, so whosoever is maintaining the slides, I will just have like this. So I hope that will be an indication of the next slide. So,
sure, ma'am.
So this is then I have transformed, you can say, my that heavy topic into this lighter topic, which is a part of that, you can say, and which covers a major part of that. That I'm just going to tell you a story of a daughter, story of a woman who's called daughter. Any woman when is born is a daughter. So the first status which any female acquires on this earth is daughter. So we are going to, have the story of a daughter vis-a-vis her property rights in the family. What is her status in the family with regard to her property rights? And this story, as I just now told you, will take us whole 1,000 years. I will start the Hindu law on this particular aspect from 11th century, and we will then come to 21st century, the law as it stands today. And in this story, you will find its story of a daughter who has faced exclusion, a story of a female who has been the victim of patriarchal biases. And in the name of love and warmth, she has been given certain rights, but those were very, very low rights. She has always been deprived of the higher rights. And then later on, this has continued for almost 1,955 years. This has continued. And then recently only, when our country got independence and we have this kind of the constitution, that ultimately certain changes in her plight started reflecting on the legislative books. And the law has again happens to be gradual. First, she was included in that sphere which is known as the property law in the family. She was included, but she was not given the equal share. And then the struggle continued. And then ultimately, she was given the equal share also. So as far as law is concerned, you will find the law must have fulfilled his obligation. But if we really wanted to know whether ultimately she got what the law has given him, this is also one of the things which we'll see at the end. Now, you have also to relate the importance of this particular topic, that is a property. You see, this is a time you are the students who have born and brought up, because I believe all of you are between 2021 years, or maybe 19 20 21 years. So you have been born and brought up at that particular time when you have been you are experiencing in a way not only the awareness about the woman's right, but also the empowerment of the woman's right. And in all the there are so many things which gives empowerment to a woman. So many things, basic things we start, at least she should be treated equally in terms of food, in terms of liberties which are there in the house, which are given to the boy, the same kind of a things should be given to her. Then it also includes this empowerment, giving her freedom to have the education, to go for sports, to go outside. So one of the things among all this is what kind of relation is of this woman in the house, primarily the daughter. Property is related with the economic empowerment of a person. So if a person is having a right to the property, that means we can say that the person is economically empowered. And you all know that how important is this empowerment, which we are saying economic empowerment. There are so many things which automatically comes to that person in the family who's earning. Okay, so not going too much into other patriarchal features. Why? Because the time is less with us. We start this daughter's story and starting from the 11th century. So yeah, the next slide please. Yes. So now I have you take you back to this particular society. You have to have assumed that that particular society was very different, as I'm talking about the 11th century. And under Hindu law, if we want to know what was a Hindu law, the Hindu law was in the form of Mitaksha school of law and Vyabhaga school of law. There were two schools of law at that particular time, which were governing the life of the Hindus. And those two schools of law were known like this, whatever is before you. Out of these two, we are concerned with the first one. Reason very simple, because out of these two schools, the first one, known as Mitaksha school of law, happened to be the law which was applicable to almost whole of the country. Number two, it was that school of law which was really covering almost all aspects of Hindu law. So whatever now I'll be telling you about the daughter in a family vis-a-vis the property, that will be according to Mitaksha law. So the law is Mitaksha. Yes. Now, according to this law, that is Mitaksha, the property in the family was divided into two categories. Those two categories are before you. The first, it was known as joint family property. And the other was known as separate property. Now, the concept of joint family property or the concept of joint family is very unique to Hindu system of law. You will not find it in any other system, maybe in India or outside India, right? So let us talk about joint family property first. We'll be talking about both the property vis-a-vis daughter's position, okay? So let us first talk about joint family property. Yeah. So Mitaksha law says in a property which is known as joint family property, only those persons have a right who are known as co-partners. This was the law, right? So the next question is, who are co-partners? So we are talking about, in this slide, you are seeing two things. One is joint family, one is co-partner. So when I'm talking about joint family property, we don't have to see it in its ordinary sense of the term. Joint family property, which operates in the joint family, Doesn't mean, in the joint family, there happens to be male, there happens to be female, there happens to be brothers, sisters, there happens to be sons and daughters, so on and so forth. So if we are saying joint family property is a property of joint family members, it is misnomer. It's not like that. Joint family property is not that property which belongs to all members of the joint family. No. Joint family property is that property which belongs to only some of the members of the family. And those some of the members of the family are known as co-partners, and they form co-partnering. And the whole problem starts from here. This is the root cause of whatever other biases the woman, the daughter has to suffer here in this concept of co-partnering. So what is co-partnering? Yeah, like just now I told you that joint Hindu family is a unique feature of Mitakshara. Likewise, co-partner is also another unique feature of Mitakshara. It is defined in its own way. But the part which is relevant here, we can say that Mitakshara co-partnering consists only and only of males. And that up to certain degrees, which are 4 degrees, right? Females have been exclusively, categorically excluded from the co-partnership. Mitakshara, good or bad, that's a separate thing, but it is very clear, very categorical that only males up to 4 degrees can be the co-partner. No female can be the co-partner. Now, if I'm saying males up to 3 degrees, it happens to be father, son, son's son, and son's son. Father, son, grandson, or great grandson. Only these. Hypothetically, if in the family there is a male, okay, person, but beyond these 4 degrees, great grandson, he was also not a co-partner. He was also not a co-partner. So, first of all females were excluded. Second, not even all males were included. Males up to 4 degrees. Now, here question arises, why this kind of law was evolved by those persons who otherwise are known as smritikas and have a very good knowledge of our shastras, dharma shastras, purans, etc. Why they have evolved it? So, the reason which is given for having this kind of law, which includes only males and that up to certain degrees, and which excludes exclusively from female, is based upon one concept or mythology which is related to spiritual ministration, theory of spiritual ministration, belief of spiritual ministration. What is this? What is this? These days, these shraddhas are going on. Yeah. And the life of the Hindus, in every year, there happens to be fortnight of shraddhas. So we know that which day in these shraddhas is for our departed ancestors. And those on that day, certain kind of a puja, etc. is done. Now, spiritual ministration is related to who can offer oblation to the departed ancestors. वो पिंडदान कौन कर सकता है? So this, the right or the capacity to offer spiritual ministration, pinddan and other kinds of the things have been given only to son or grandson or great grandson. That's it. Son, grandson or great grandson. Only these 3. Or 4 degree hoge the person with respect to whom which we are talking about. Only these 3 generations next to that particular person can offer spiritual ministration. So we have our own, because I'm talking Hindu law. So Hindu law has to go by the Hindu, whatever mythology or beliefs are there. In Hindu beliefs, we talk about those moksha, we talk about that the departed ancestor should have their abode in the heaven, etc. And then there are certain other things, how a person can get that particular ultimate moksha. And the things happens to be that these persons have to offer oblations to the departed ancestors. So, that is one thing. Here, what the ancestors are doing, they're talking about their benefits. They want to have certain benefits, spiritual benefits, religious benefits. And they have adopted this mechanism that these are the procedures. This is the puja, and this puja has to be done in this way. That's fine. But who has to do that puja? Only son, grandson, great grandson. Okay. So the thing is, why not the granddaughter? Why only the son? Why the daughter? All this. Why the daughters have been excluded? If the question is children, grandchildren, or great grandchildren, if the question is that, then why the females are excluded and not the males have been retained? I'll tell you this answer also, but I will retain this if somebody of you remind me in the question answer session. Why? Because there is a deliberate reason why I'm not telling you now at this, even though you should know that reason also. Okay, very interesting reason is that. However, here my emphasis on this slide is to tell you that ancestors have set a mechanism to have these religious benefits, and they have chosen these persons who can confer on us the benefits. Now, what will they get? You are getting the religious benefits from son, grandson, great grandson, but what they are getting in return? What son, grandson, great grandson is getting in return in giving you such heavenly benefits? Here comes the right in the property. Next slide. Here comes the right in the right. It's known as right by birth. It's not a less right. You know, fundamental rights we have come to know much later. Hindu law, such an old law, has this concept of right by birth in the joint family property. So I tell you, it was a kind of a deal. You give me these spiritual benefits and I will give you the property. And therefore, these three persons were given the right in the property, and these only up to 3 degrees were known as a co-partner. They were given a certain title. They were given a privileged title, and that title was co-partners. Only co-partners can have right in the property. And who are those? Who are these? Who can offer these, whatever I have explained you? Fine. So I have just taken an example to explain you. Say, if a family consists, it's a simplest example which I could have thought of. If a family consists of father, mother, son and daughter, okay? So it's a family, we will say it's a joint Hindu family. All 4 are members of joint Hindu family, whether they are male or female. All 4 are members of joint Hindu family, but all 4 do not have right to joint family property. Only co-partners have right to property. And who are the co-partners? Only F and S. Only these 2 persons. Why? There is a rule. What is the rule? Only male members up to 4 degrees. Here there are 1 degree father, 2nd degree son. They are both under 4 degrees. It's a technical formula to know whether any male is a co-partner or not, right? So out of these 4 who are members of joint Hindu family, only 2, these males are co-partners, and therefore only these 2. And if I compare with reference to the daughter and the son, it is only son in comparison to the daughter who has got a right in the property, in the joint family property, and not any right. It's a very, very superior kind of a right, very strong right, very powerful right, which is known as right by birth in the joint family property. Since the co-partners have a right in the property, they can ask for partition. And there is another unique feature. If any one of them dies, then the property goes to that co-partners who are surviving. So these are the 3 basic features which go hand in hand when we talk about the property there in the family. Yeah. So in the previous example, if the father dies, son, because you know, in the lifetime of the father and son, these 2 were the co-partners, right? So if any one of them is dying, the other is surviving. So the other surviving co-partner will get the benefit of survivorship and will take the property, the whole of the property on the death of the father, to the exclusion of the daughter in the previous example, and of course, mother too. Because even though I'm focusing on daughter, but by way of reference, I'll be talking about other women also, but our emphasis will be primarily from the point of view of the daughter, right? Okay. Next slide, please. Fine. Now I take you to the separate property. So far we had seen the joint family property is a complete exclusion of the females, complete exclusion of the daughters. Now come to the separate property. Say, if in the same example, it is the same illustration, father, mother, son, and daughter. Say, if this father dies leaving behind separate property, okay, then who will inherit it? Then according to the Mitakshara rule of succession, again, son will get the property. Again, son will get the property. Next slide, please. Yeah. Now, there is one thing, if we are talking about the law, in both the cases, with the same example, father, mother, son, and daughter, it was a son who was getting the property, but he was getting property by different rules. With respect to joint family property, son was getting the property by rule of survivorship. Why? Because he survives. Now, with respect to separate property, he was getting the property by rule of succession. Now, rule of survivorship, I have explained you whatever was required in this context. Now, what is a rule of succession? Rule of succession, according to Mitakshara, gives us a list. Says, if a Hindu male dies, leaving behind separate property, then what are the rules of succession? It says, first of all, the next slide, please. The rule of succession says, first of all, his separate property will be taken by son. If one son, one son. If 5 sons, all 5 sons will take. All 5 sons will take. If 10 sons, all 10 sons will take. Per capita, equally. However, if a person's son has died before him and he is leaving behind son's son, then he will take the whole of the property. Or grandsons will take whole of the property. Now, let us say, unfortunately, during his lifetime, his son has also died and his son's sons has also died, but there is a great grandson. So, great grandson will take the property. Rules of succession to the separate property. It is only when the person is dying, not leaving behind any one of these 3 categories, the widow of the woman takes the property. It is only when a person dies leaving behind no son, grandson, great grandson, and the widow, the daughter takes the property. But in the illustration which I have taken before you, father, son, father, mother, son, and daughter, there was a son, there was a son, there was a son, and therefore daughter was not getting any property. Son is number 1, daughter is number 5. So first of all, the property will go to number 1. It is only when number 1 is not there, 2 is not there, 3 and 4 is not there, the daughter will get the property. So this is the rule of succession. So what picture comes out? The picture comes out that as far as joint family property is concerned, survivorship is concerned, daughter has absolutely no place, how low soever. But as far as succession to separate property is concerned, she has certain place. She has certain right. But that right is at number 5 is very low. She will get the property only when these persons are not there. Or to simplify the thing, in between son and daughter, if a person is dying, leaving behind son and daughter, no matter whether he is dying, leaving behind joint family property or separate property, it is a son which will take the property. Daughter is excluded. So far it's a story of the exclusion of the daughter. Joint family property, survivorship, absolute exclusion. Separate property, of course, very low situation, but in the presence of the son, again total exclusion, right? Okay, so let's proceed further. So this was happening from 1100 to, okay, before telling you the next law, yeah, one thing. That is that though daughter was not having a right to joint family property, but she was having, okay, hearing, and she was having, as I told you, a lower right of succession with respect to separate property. But Mitaksha law has gave her one right, being a member of a joint Hindu family, which was known as right of maintenance. And the right of maintenance has special reference to marriage expenses. So, as a member of a joint Hindu family, it's not that she was having no right. She was having a right. But what was that right? Right to maintenance. Maintenance mein kya hai? Roti, kapda, makan. Yeah. Okay. In what way you are giving the roti? In what way you are giving the kapda? That's a different kind of. There's so many restrictions on the dresses, this and that. There may be so many restrictions. Who will eat first, etc. But at least she was given right of maintenance. And since Hindu law has placed, so much importance on the wedding of the daughters, and therefore special mention was of the marriage expenses. Now, all these rights are there with the son also. It's not that she is having these rights, but the sons are not having these rights. All these rights, when the boys, the sons are married in the family, whether it doesn't entail that kind of expenditure, we can say, yeah, comparatively, daughters, the kind of the tradition it is, custom it is, it's more expenses are on the daughters, but that doesn't mean that no expenses are when the son is getting married. Or is it that the sons don't have anything which is spent on their maintenance? So all these rights are there with the sons also. But another thing which is really a very superior kind of a right, strong kind of a right to property. Of course, I have just now explained you how she was excluded by Mitaksha from that right to property, right? Okay. Then this continued for 950 years, 950 or 60 years. Then came there the year of 1937. Okay, 1937, one act was passed. Yeah, in 1937, one act was passed. The name of the act is Hindu Women's Right to Property Act. Okay, this was an act which has given property rights in the family to only one kind of the woman. And that one kind of the woman was known as widow. So woman is a misnomer here. It should have been Hindu widow's right to property. But the name is woman. But if you read, it's a very short act. If you read the act, you will find it doesn't talk about all women. It talks about only one kind of the woman. Okay. So if we are talking about whether daughter's position changed, the answer is no. This act, even though has brought changes with respect to the plight of the widows, but it has nothing to do with the rights of the daughters. Yeah. Then came the year 1947, we got independence. 1937 provision was of British era. Then came 1950, we got our own constitution, the constitution which guarantees equality of sexes. Article 14 is there, then protected discrimination is there, 15, 16, so on and so forth. And then there came a fleet of legislations. Some of the legislations in the area of Hindu law also, and we are concerned with one of such legislations which were passed in the year 1956. The name of the act is Hindu Succession Act 1956. Now, when this act was passed, this has brought about what we can say revolutionary changes in the law of succession. And one of that revolutionary changes was this, which is written on this slide, that for the first time, daughter was made an heir to the father, but only to the separate property of the father. Just now I had given you the example that if the person is dying, leaving behind son and daughter, son will take the whole of the property. But now not. the daughter will also take the property. So it was really a very radical change, path-breaking, what you can say. If we have to analyze the status of the woman or the plight of the woman or the empowerment of the woman, right? Okay. Next slide, please. Yeah. So if I just try to explain it with the help of the last example, in the last, we have been continuing this example. A family consists of father, mother, son, and daughter. Now, if the father now dies any year after 1956, her daughter will also inherit along with the son. She will inherit along with the son. In this example, this M will also inherit, but my focus is not on her. Okay. However, if the year of the death of the father is different, it is a year, any year before 1956. And I have just now told you that she was not inheriting in the presence of the son. Yeah, I hope you understand. Along with the son and in the presence of the son. Before 1956, she was inheriting, but at number 5. Only when son, and those other persons were not there. So what the law is now in 1956, she is inheriting, even though son is there, along with the son. At the same level as the son is there. And the same share of the property. If I just simplify this, and if I say a family consists of father, son, and daughter. Let us see, mother has died before. And the father is dying now, leaving behind separate property and leaving behind son and daughter. Daughter will inherit along with son. Not only that, she will also inherit equally. Say, for example, if the father has left behind the property 100 crores of rupees, then 50 crores son, 50 crores to daughter. Okay, but that was only with respect to the separate property. Okay, next. Now, what about joint family property? What about that property? With respect to joint family property, Hindu Succession Act retained the concept of Mitakshara Co-Passionary. It was retained. But one change was made, which was an improvement on the previous law. And that change or the improvement was in the form of the proviso. And what was that? I'm just telling you the relevant portion, not the whole of the proviso. Okay. From the point of view of the daughter, the proviso says, if co-partner is dying, leaving behind joint family property, and he's also survived, for example, the daughter, then survivorship will not be applicable. It is the succession, rule of succession under the Hindu Succession Act, which will be applicable. Now, let me illustrate you. Say, this is a family. Okay, I should have removed M here. Okay, I have done the editing in the other slide, but not here. You just assume that there is a family consisting of father, son, and daughter. Why? Because that will best explain. I can retain M also, but if I delete the M from here, that will better explain. Okay, so there is a family consisting of father, son, and daughter. Right? Father is forming a joint Hindu family, co-partnership with the son. He's forming a joint Hindu family with the daughter also. There are 3 members of joint Hindu family: father, son, and daughter. But if we want to know who are the co-partners, even after 1956, even after Hindu Succession Act, there are only 2 persons, father and son. Why? Simple rule, they are male persons and they are within those 4 degrees. They are the co-partners and they are having a right by birth in the joint family property. Right? Now, if father dies, 1956 Act says, if father is dying as a co-partner and he is survived by a daughter, his right in the property will not go by survivorship to son, but it will go by succession. Now, what is succession? Succession says the property of the person will go to both son and daughter. That is succession. Survivorship in this example gives right only to the son. But succession under 1956 gives right to both son and daughter. Okay. But then there was a problem. Why? Because Mitaksha co-passionary was retained. And the law says that the share of the father will go in equal share to the son and the daughter. So we have to know what was the share of the father. Because when you will study that law, you will come to know that even though each co-partner have a right by birth in the joint family property, but his right is fluctuating right. He doesn't know how much he is entitled to. And his right becomes fixed 1/3, 1/4, 1/5, etc. only and only at the time of partition. But in this example, the person has died without a partition. So how to know what was his interest in the joint family property, which will go by succession? So in order to solve this problem, the legislature under Hindu Succession Act has incorporated what is known as a concept of notional partition. That is, we will assume that immediately before his death, there was a partition. Okay. Now, let me continue that example, that the joint Hindu family property consisted of 100 crores of rupees. Okay, this is a joint family property. In this example, 100 crores of rupees. This person is dying, leaving behind his share in 100 crores of property, and he is survived by son and daughter. He dies after 1956. He dies leaving behind daughter. Therefore, his interest will go by succession. But what is his interest? Notional partition. In notional partition, 100 crore will be divided half to father and half to son. Son will take 50 crores and father will take 50 crores. Now, this is 50 crores which is father's share in the joint family property, which will go equally by rules of succession to the son and the daughter, with the result that son will get 25 crore and daughter will get 25 crore. Right? Okay. So when in the year 1956, this act was passed, and this proviso happened to be there. We were again applauding this particular act. You know, the daughters are also now can inherit the share of the father in the joint family property. So it was praised. But then later on, the working of the Hindu Succession Act was examined in more depth. And in that analysis, it was found, oh, daughter is getting, yes, after 1956, daughter is also getting along with the son a share in the joint family property of the father, but see how much she is getting. See how much she is getting. She is getting just 1/4 of what the son is getting. Why? Because you have retained Mitaksha co-passionary. Why? Because notional partition is there. So if he has died leaving behind joint family property of 100 crores of rupees, so first of all, in notional partition, the son is getting 50 crores. And then he is getting half of 50 crores of that particular property, and she is getting just 25%. So where is absolute equality? This is not the equality in substance. The equality is only in the sense that daughter is getting along with the son. But equality is not in the sense that she is getting equal to that of the son. And not, I mean, that the disparity is also not marginal, insignificant. This is quite substantial. The example is before you. I had given with 100 crores that she is ultimately getting only 25 crores. And the son is getting 75 crores. So when this thing was highlighted, we participated in so many conferences, seminars. National Commission of Women has also taken a lead herein. And then gradually, states came forward from the south. The next slide, please. And they paid their attention to this kind of inequality. Okay. The next slide, please. So, first of all, certain state amendments were made in the year 1986. This is 86. 1986, 89, 94. What did they do? What did these state amendments have done to Hindu Succession Act? They had made daughters also the co-pastors. right? Daughters are also made the co-partners. Why? Because whatever she was getting less, it was because of the fact that in notional partition, she is not getting the share in the property. Why? Because she's not a co-partner. So when these things were done at the piecemeal level, then there was another force coming from the women organizations that there should be an amendment at the central level. And ultimately, in the year 2005, we got this law changed by virtue of Central Amendment 2005, and now daughters are also made the co-partners, right? From 9 September 2005, daughters are also made the co-partners. That means now, if there is a notional partition, she will get there also, and then she will get as an heir also. Okay, so 9 September 2005 is really, I will say, historic day in the women's studies, when the daughters were given the right in the property equal to that of the sons. Now, let me tell you, in the year 1956, when Hindu Succession Act was being framed, there also at that particular time also there happens to be certain discussions. Should we abolish Mitaksha co-partnering, or should we retain Mitaksha co-partnering and make the daughters co-partners? So Rao's committee is a very famous committee on that. So this idea was laughed at. Oh, what are you talking about? Mitaksha and then daughter, the co-partners? This is nonsense. So that thing which was laughed at in the year 1956 is accepted in the year 2005. Mitaksha is retained, and daughters are made the co-partners, right? Okay. Then comes other problems or the issues. After this 2005 amendment, and those issues related to the judicial interpretation, right? You see, whenever any new law comes or new amendment comes, even courts take its own time to understand that new law. But as far as this amendment is concerned, it's not only the high courts who have taken the time, even the Supreme Court took time to have certain consistent view of the matter herein. And because I'm just touching those areas which are related to this daughter's perspective, even though this amendment in substance is a very good amendment, but the way it is drafted has many loopholes. Okay, and that is also one of the reasons why there happens to be so much uncertainty in the judicial interpretations. So certain issues which have arisen after this amendment regarding its scope were whether it is having retrospective operation or prospective operation, whether the because the language is daughter of a co-partner becomes daughter. Okay, that is the language of 2005 amendment. Daughter of a co-partner becomes a co-partner by birth. So another issue was whether this father should be live at the time when this amendment has come into force. So high courts have given different views, then come to Supreme Court. Even Supreme Court has given different views in the year 2015. In the Prakash case, the court have said, no, it is not having retrospective operation. That means daughters are made co-partner. They will get a right in the property only when the father is dying after 9 September 2005. And they have given this doctrine, one principle, that there should be living co-partner and living daughter. Living co-partner and living daughter, right? Then came a judgment in August 2020, 11, year back, in Vinita Sharma case. And in between 2015 and 2020 came few other judgments also from the Supreme Court, where the law was becoming more and more controversial. I will not say confusing, but controversial. And therefore, a larger bench was constituted in the case of Vinita Sharma. And the judgment is authored by Justice Arun Mishra, and the other judges were Justice Abdul Nazir and Justice Shah. So it's a larger bench. Now they have given the widest possible scope to 2005 amendment. by saying that this amendment will have a retrospective operation. As a matter of fact, the word which has been used by Justice Mishra is retroactive operation. Retroactive operation. Okay, so they say, and they have also maintained a distinction between retrospective and retroactive. They say retrospective operation is that which operates from the back date, backward, but retroactive operation is that which operates in the future, but it is based on the antecedent act. So they say by 2005 amendment, daughters are made co-partners by birth. By birth, birth is an antecedent event, but they can claim this right only after 9 September 2005. And another controversy was also set at rest, that whether father should be alive on the date of the amendment. So the larger bench in Vinita Sharma case have said no. So they have removed living co-partner. Co-partner here is the father, okay, in reference to the daughter. So they have removed the living co-partner, and they have now given us the principle of living daughter. Of course, daughter will be living. She's living, therefore she's asking, she's claiming her right. So now, at least for the last one uh, year, this controversy to a large extent has been set at rest by the courts, even though still it is giving rise to so many issues. It's not that now there are no issues. Still there are issues on this kind of a judgment also. But yes, at least on these 2 points, the law of the land is now clear. And in one word, that is widest possible interpretation or scope is given to the amendment. Okay, so whatever I have told you so far was the role of legislature and the role of judiciary, and you have seen that how from exclusion the stage came from inclusion, and from the inclusion to the full rights as far as legislature is concerned. And it's commendable as a matter of fact. And as far as role of judiciary is concerned, the judiciary has also played is a very dynamic and very progressive role in giving the daughters full rights, or the rights which are equal in substance to the sons. Okay, but now the another issue also is relevant, okay, apart from legislature and the judiciary. That is, what is the reality at the ground level? Okay, in order to know the reality at the ground level, you need not have to do any survey. You need not have to see any working paper or any report. Just in your house, you ask your mother whether your mama has given her share. You just ask your father whether your father has given share to the bua. You will come to know what is the ground reality. Okay, so implementation doesn't lie outside. Implementation of this particular amendment lies within our houses. And if it is, I'm seeing it's a strength of whatever it is, it's close to 150. So you can have on your own survey, and will come to know what exactly, to what extent this has been really effective, whether they have really got property, they have got the right to property, but whether they have got the property or not. So whatever now we know through the seminars and the conferences, and of course in social services and other whatever other research is going on, the picture is not very rosy. So the daughters are still struggling to get their property. They have got the right to property, but still they have not got the property. But it may be a long way to go, but I mean, wherever she has come now, whatever the legislation has strengthened her, whatever judiciary has strengthened her, that itself is a very, very big achievement in this particular area. So it was a very, very brief and short overview, you can say, of this. If you have any question, I will be more happy to, entertain the questions to clarify whatever point you may like to.
Thank you, ma'am. Now we will move forward to Q&A session. Ma'am, there are some questions in the chat box, and I will read it for you. Ma'am, the first question is asked by Vinit Agrawal. Ma'am, why spiritual ministration rules were adopted in co-parsonary?
Okay, so I need not, see it. You will be seeing it. Okay, that's fine.
Ma'am,
I may
actually,
close it. I may close it. Yeah. Uh, you see, the reason is purely religious because, you will learn that in India, so far, we are not having family law. We are having personal laws. It's again in 21st century, it's a unique feature. You have Indian Contract Act, but we do not have Indian Family Act. Okay. Of course, I'm directing you to that particular debate, which is there of Uniform Civil Code. So each community is governed by its own law, personal law, and personal law is religious law. So it's a belief. When I'm talking about the religion, it's a religious belief that these kind of spiritual administration one should have, and then the other things.
Thank you, ma'am. The second question is asked by Manjeet Singh Jat, and he is saying, ma'am, can adopted son be co-parsonary?
Yes. As a matter of fact, when you will come to the family law, you will come to know that according to our classical Hindu law, there were 12 kinds of the sons which fall in the category of the adoption. So it doesn't make any difference of the adoption. Adopted son was having the same rights as the natural born son. Okay. Is there any other question on spiritual ministration? Otherwise, I would. Okay, you go on. You proceed. I will remember it. Yeah.
Yes, ma'am. Ma'am, the next question is asked by Kashish. And what was the actual reason of excluding women's and daughters out of the property and co-partners?
Yeah, I love this question. Actually, I was looking for this question. Kashish has asked this. Why? Because this is a fundamental question. We know co-partnering includes only males up to this degree, but exclude female. But why female were excluded? Okay. Since this is revolving around the religion, Hindu law, Hindu religion. In Hindu religion, there is a belief that when a woman undergoes a monthly cycle, she is not regarded pure according to our classical Hindu law. She is not regarded pure to do certain puja kind of the things. उसको मंदिर में जाने की भी मनाही होती है. There are certain other kinds of the things pertaining to religious matters which she is prohibited to do. Okay. Now, the basic concern of the ancestors was to get spiritual ministrations, right? And they were having children before them, son and daughter. And the concept of purity was also there. Now, the women are, this is again a belief. Now, the CEDAW Convention on the elimination of all, on the elimination of discrimination of all kinds of forms against women, and now says no discrimination based on any belief, on any religion. Now, these things are not there. But I'm talking about the law which operated there 1,100 years before. At that particular time, this concept of purity was there. So they don't know that at a time when they need the spiritual ministration, whether the girl is pure or not pure. They didn't want to take a risk. Because no such kind of, in their sense, disqualification, okay, in their perspective, is attached with that. This is a biological kind of a thing which should be respected. But I mean, they were so much obsessed in getting the spiritual ministrations that going by this concept of purity, they have chosen the males. So it's also a very an apt example how the biological differences have resulted in the patriarchal biases. Okay, but the question is not only, had it been only given a spiritual ministration, okay, fine. But whosoever will give those benefits will get the property. The problem comes there. Because they have attached it, na? It's a deal. You give me this, I'll give you that. So that's one of the reasons why she was
And the next question is asked by Kshitij Raj Purohit. Is there any limitation period provided in the Act to claim the right of succession? And after that, would it be considered that either son or daughter has waived off the right by succession over the property?
uh, I mean, there are so many things which you have included in your question, and I have my doubts if a person is very clear about what what he or she wants to ask. You see, we do have one law of limitation, which is a general law of limitation, which is applicable to any kind of the suit or these kind of the things, which one can, I mean, go in the court of law. But looking to the kind of the cases which have come before the courts, if I'm not exactly aware of what exactly is the question, if you can frame in the form of the illustration, I can come to know. The question is very general, and therefore the answer is that yes, there is a general law of limitation which may be applicable herein. But the general law of limitation will vary according to that particular case, that particular illustration, number one. Number two is wherever there is a law of limitation, there happens to be relaxation also, and the courts are liberal also to relax that. Those kind of things.
Okay, ma'am. Next question is from Garima Shukla. Ma'am, according to recent amendments in Hindu Succession Act, can women challenge property distribution where they have already accepted a settlement?
Okay, first of all, 2005 amendment has not given rights to women. It should be very clear, because I found this confusion in the minds of many law persons also, who are not the student of family law, but they are the law professors. So 2005 amendment have given rights only and only to daughters, not to women. So this should be very clear. Daughters are made co-partner. Women are not made co-partner. Female are not made co-partner. Okay? Only daughters are made co-partner. Right? So bringing that thing in on the question, if I go by Vinita Sharma case, oh yes, she can. She can. Because in Vinita Sharma case, the court has very clearly says that the moment she is born, she might have been born in the year 1940, in the year 1960, in the year 2000. She has become a co-partner, but she can claim the rights of that co-partnership only from 9 September 2005. So if you go by Vinita Sharma case, oh yes, she can. Because what she's claiming is right by birth. She could not have claimed earlier, but now she's claiming why? Because she is made eligible now, 2005 amendment, retroactive operation. This is what exactly has happened in Vinita Sharma case. She can get it reopened to get her share. So it is disturbing. In one way, this is disturbing many families where this thing has happened. Distribution of the property has happened. Yes. Any other question?
Thank you, ma'am. Now I would like to call Ms. Kiran Vaishnav for vote of thanks. I think questions are done. Kiran,
Thank you,
over to
Muskan.
you.
Thank you, Muskan. Life is not a competition between man and woman. It's a collaboration. Today, my words are not enough to express my thanks. On behalf of Department of Law, Prestige Institute of Management and Research, I, Kiran Vaishnav, would like to express my sincere gratitude to Dr. Usha Tandon ma'am, shared her valuable knowledge addressing various aspects of women's rights and her position in a Hindu family and also different dimensions of Hindu law. I would like to thank Assistant Professor Kamlesh Jain sir for organizing today's EML and for his support and guidance at every step. I also thank Assistant Professor Sayali Bandi ma'am and Assistant Professor Navrati Dongre ma'am for their presence during the session. And I also thank Assistant Professor Nakul Singh Chauhan sir for his support throughout the session. A heartfelt thanks to student coordinators of EML committee, Ms. Priyanshi Jain, Mr. Kshitij Rajpurohit, Mr. Nishant Jain, and other committee members who have worked hard and made it a true success. And amongst all, I thank all the participants for their patience listening and showing their interest in this EML. Once again, thank you everyone who has assembled here. Thank you, ma'am.
Thank you.
I would also like to thank you, ma'am, for sparing your valuable time for our students. And we would love to have you in the institute in person once we are done, once we are through with the pandemic. It will be a great experience for our students. So thank you so much, ma'am, for taking out your valuable time for us. It means a lot to us. Thank you so much. I'll be ending the meeting now, ma'am. Thank you.